Ladies and gentlemen, welcome back to the People's Law School. I'm so proud to be here tonight because tonight I have with me my daughter, Becca Brinkley. Becca is a lawyer up in Nashville, and she and I have a lot in common. We're both licensed to practice law in the state of Alabama and the state of Tennessee. We both graduated from the University of Alabama School of Commerce and Business Administration with the same degree. We also graduated from the University of Alabama School of Law with the same degree. There's about a 31-year differential there. The grades, she was a lot closer to the top of the class than I was. But I'm so glad to have her with me. She practices with a big firm in Nashville, Tennessee, and is a litigator with them. And I'm just so proud to have her with me. Tonight, we are going to cover several topics. Over the last few years and in the last few weeks, several of you have asked me many things, and I thought we would just address them. We will be going through various areas of the law, and so I thought maybe we would begin with, Becca, if you could take the first question. And the question we have is, Becca, will you tell us what safeguards people have in the event they get sued? Will you tell us why there really aren't frivolous lawsuits? What rights does a person have when he's sued? This question comes up all the time. What can you do? So, Becca, fire away.
Well, there are actually a lot of safeguards that keep frivolous lawsuits out of the courts. The Alabama Rules of Procedure, as well as the Tennessee Rules of Procedure, are modeled after the federal Rules of Procedure and have been for decades. If a person wants to file a lawsuit in Alabama, for example, that person, before they can do anything else, has to pay $600 in advance court costs before they can do anything. Now, that alone deters a lot of people from filing lawsuits in the first place. The rules of procedure that I mentioned also provide safeguards, and there are actually 9 different stages that a case can be reviewed before a plaintiff ever gets a dime. And I've actually brought this chart which shows all the different stages that a case can be reviewed and how a defendant can get a lawsuit that has been filed against it dismissed. The first way that a case can be dismissed is if a defendant files within 30 days of being sued a motion to dismiss. Now, of course, they not only have to file it, they have to win it. But they file the motion to dismiss within 30 days, and in the motion they ask the trial judge to review all the allegations in the complaint and for it to consider, the trial judge to consider all the allegations are true. And if the trial judge considers or assumes that all those things are true and still determines that the plaintiff still doesn't have a case, then the trial judge will throw the case out right then and there. Or he should. Another way that a case can be dismissed and a defendant can get out of a lawsuit is by filing and winning a motion for summary judgment. Now, a motion for summary judgment is more involved than a motion to dismiss, and in that motion, both sides have to present some evidence. And if the trial judge determines, and this evidence can be in the form of depositions or affidavits or written discovery, and if the trial judge determines that there are no genuine issues of material fact at issue between the parties, and if the trial judge determines that the defendant is entitled to judgment as a matter of law, at that point the trial judge will and should dismiss the case. Now, another way that a defendant can get out of a lawsuit is during trial. Now, if a plaintiff survives the motion to dismiss and a motion for summary judgment, in most cases the case will go to trial. Now, in the beginning of the trial, the plaintiff will put on all of its proof, and at the end of the plaintiff's proof, the defendant has an opportunity to ask the judge to direct a verdict in favor of the defendant. And what that means is that the trial judge will consider all the evidence before it at that stage, and if it determines that the plaintiff still hasn't put on enough proof to win its claims, then it can dismiss the case right then and there. So, assuming that the plaintiff has survived the motion to dismiss, the motion for summary judgment, and the motion for directed verdict, then the defendant will put on its side of the case, and the case will go to the jury. Now, as all of you know, in order for a plaintiff to win a jury trial, then the plaintiff has to get the unanimous vote of 12 citizens. So, At that point, we've got the number 12 up here on the chart. At that point, 13 people have reviewed the case. So if a plaintiff wins at that point, 13 people have reviewed the case, and in most circumstances, the plaintiff has survived quite a few motions. Now, even after a trial, a plaintiff faces some hurdles because the defendant can get a case turned around by the trial judge even after the trial. After the trial, the defendant can file what's called a motion for judgment notwithstanding the verdict. And at that point, the defendant will ask the trial judge to reconsider his decision. And if the trial judge at that point decides, you know, the plaintiff really didn't put on enough proof, then at that point, the judgment can be entered in favor of the defendant. And another way that the defendant can get a verdict turned around is by filing a motion for a new trial. And in that motion, the defendant asks for exactly what it says. They ask for the court to grant the party a new trial. And at that point, the trial judge considers whether there was any juror misconduct or anything else that might have happened that tainted the trial. Now, I'll tell you, at my law firm, I think this case was about 20 years ago, but there was a several-month-long case that several of our senior attorneys were involved in, and this has become kind of a legend. But all the parties to this lawsuit spent all this time and money, and at the end of the case, we received, or one of our administrative assistants received an anonymous telephone call from someone who said that there was inappropriate conduct and an inappropriate relationship between one of the jurors and the court officer. And at that point, after a several-month-long trial and after some motions were filed and all this time and money was spent, a new trial was granted because there was, in fact, an inappropriate relationship between those two people. And the jury had been getting information that it otherwise shouldn't have received. So things can happen. After all of this, other ways that a defendant can keep a plaintiff from recovering any damages is they can appeal to the Alabama Civil Court of Appeals. Following that, there are other appeals. You can take it after the appellate court. It can go to the Alabama Supreme Court, and it can go so far as to the Supreme Court of the United States. So, as you can see, there are 9 different stages that a case can be reviewed. If you add it up, there's a chance for 36 people to review a case before the plaintiff sees one crying dime. So, that said, and we mentioned appellate courts and appellate court judges. Justice Scalia of the United States Supreme Court offered his 2 cents on appellate court judges, and I'm going to read this to you. Trial judges preside over the battle on the plain. Appellate judges are a tribe who live in the hills and ride down after the battle and shoot the survivors. Supreme Court justices are like the Court of Appeals justices, except they have less compunction and shoot the women and children as well. At this point, I should also mention Rule 11. Under Rule 11, an attorney, by signing his name to a pleading in a case, certifies that based on his knowledge, there's a basis to support the pleading and that the pleading is not just filed for delay. An attorney himself can be sanctioned, and sometimes attorneys are sanctioned, and if the pleading was filed in bad faith. Also, a lawsuit can be filed against someone who brings a lawsuit for the wrong reasons. This is called abuse of process. And all of this said, I think that there are adequate safeguards within the system today that keep control over the process. So, now that I've answered that question, Dad, will you please give us your thoughts on employment law?
You know, I'm so glad you asked me that question. Here, stand right here with me. Because I'm going to try to say in about 5 minutes what Kerry Riley took 1 hour to say 3 weeks ago, okay? Let me tell you about employment law. It's very simple. In Alabama, you can be fired for a good reason, for a bad reason, or no reason. Is there any question? This is a free country. Slavery's been dead in Alabama for 165 years. You don't own them, they don't own you. Competition is the law of the land. I know that with Kerry, we all heard last week about all these technical reasons why you could and could not sue, but let me tell you the bottom line. The bottom line is that competition is what makes America great. Competition is what makes you get up every morning and do something great. That's what America is all about. Think of Eastern Europe when it was under communism. You know, you'd pretend like you're working and they would pretend like they're paying you. And that's the way it worked forever and ever and ever. Nothing got done, their system went to pot. That's what employment law is all about in America, particularly in Alabama, where we're taking all of the car industry of Michigan and putting it right here between Montgomery and Ardmore. But federal law, let me add this, federal law has changed the landscape. And I really do believe that the federal government has done some great things and things that we don't like. I think of years ago, I'm something of a history buff. I think of Harry Truman, who made some very hard decisions 50 years ago, and nobody liked him. He wasn't very popular, but I think he was right. And the federal government says that thou shalt not, regardless of your Alabama rules and otherwise, you cannot discriminate on anybody because of race, creed, sex, or religion. Real simple. Now, if you do that, the game changes. Also, I will tell you that under federal law, you have to have 15 employees to be sued under some of those draconian federal statutes. But if you discriminate against someone because of race, creed, color, or sex, then in that time you have opened yourself up to a can of worms, and it's a whole different game regarding your employment situation. I will tell you that in America, we're about responsibility. One man is supposed to do it, or a woman, they're supposed to do their job. And that's the way it is. And again, I say that that's why we're great. Also, I will add, there's one caveat to all of this. If you have a contract with your employer, obviously you and that employer are bound by the terms of that contract as to the amounts. But in regard to a contract, the most important thing about contract law is that a contract must be definite as to its terms. Terms as to how much they're paying you and how long you're supposed to stay there. Speaking of contract law, Becca, I will turn that topic over to you.
Now, a lot of people ask if a contract has to be in writing to be legal. Does anybody know the answer to that question? You're right, it does not have to be in writing to be legal. But there are some contracts that have to be in writing to be legal, and there are Alabama statutes which address that. For example, Alabama Code Section 8-9-2 says that in the following situations you have to have a signed writing or a memo to be legal, to form a binding contract. And I'm going to give you 8 examples. First, any contract that lasts more than a year. Think about your lease. Number 2, any promise by the executor of any estate. Number 3, any promise to pay the debt of another. 4, a promise to marry. Number 5, any contract to buy or sell land. And sometimes you get into issues of, what's land? Does it include a barn? Does it include a mobile home? Number 6, any contract to make a will has to be in writing. And you think about second marriages by older people with young children, or with children. Number 7, any agreement to lend money or to forbear or modify the terms has to be in writing. And number 8, any agreement to sell stock on a national stock exchange. Furthermore, under the Uniform Commercial Code, which a lot of people know as the UCC, any contract to sell goods, and I mean goods, not services, any contract to sell goods over the amount of $500 has to be in writing. You think about an automobile or a sofa. Sofas cost more than $500 these days. So I'm going over these rules of contracts with you so that you will know how to conduct yourself in the business world. They say it's not the crook in the modern business world that we fear, but the honest man who does not know what he is doing. It should also be observed at this point that the failure to act in good faith in a normal contract case does not create liability, as for example in a tort action or in insurance bad faith cases. Punitive damages and bad faith are irrelevant in contract cases for the most part. The logic here is that sometimes in our laissez-faire capitalistic society, sometimes it is a business decision to breach a contract, assume liability, and to pay a sum certain in damages, regardless of what you promised. So, Dad, in these bad economic times, let's talk about bankruptcy. What can a creditor do when you are in financial difficulty?
Let me tell you that my dear friend Ron Sixtus and his wonderful partner talked about bankruptcy. And as a general practitioner, I will tell you that these are the types of things, and Becca and I are going through topics that every lawyer needs to know. In fact, I will tell you every lawyer does know. A lot of lawyers just simply won't do it. Like most of my trial lawyer friends, and I am a trial lawyer and proud of it. But as a lot of you know, because I grew up with you, is that I grew up here in Huntsville, Alabama. I tell people I'm a small town lawyer in the big city of Huntsville. But when you grow up with all of your friends, you can't run away from them when they come into your door and say, I need some help. So I've tried to be proficient in all of these areas that all of my other friends know how to do. We all know how to write a will, do a deed, or even file a bankruptcy petition. It's just that a lot of folks don't want to, and I say it's just because they don't have any friends or won't help them. Now, I'm telling you all this because, yes, I did bankruptcy work up until about 2 years ago when President Bush changed the bankruptcy laws so that they made them so complicated. I said, skip it. I'm just not going to go there. I'm too old to learn it again. But here's the law. Bankruptcy law is this. If you bankrupt, you can only keep $5,000 in equity in your house. Your wife can keep $5,000 as well. You can only keep $3,000 in personal property, okay? A lot of people who come to see me and want to sue, file an action against somebody, they always want to know, what's the worst thing that can happen to me? I mean, they're in tears. They're so broke and beat up from whatever the defendant did to them, and they want to sue. First thing I tell them is it's going to take a year or two. In Huntsville, Alabama, 11 to 13 months to get to trial. And then after that, it will take another year or so if people appeal. But understand that, meanwhile, back at the ranch, your creditor, the people who are after you, here's what they can't do to you. They can't take the shirt off your back. That's real important, and a lot of people think they can. No, they can't. They can't take your, by statute, they can't take your cooking utensils. They can't take your stoves, your tableware, your bedding in bed, your vehicle in use, your clothes. It is subject to a $3,000 value. They can't take your cemetery lot. Now, this is important. Now, when you're in that situation, you need to know these things. Remember, $5,000 in equity in your house, $3,000 worth of personal property. Also, there are other things that are exempt. If you are working, they can't take but 25% of your pay if they garnish you. In other words, if I have a job making $20,000 a year or taking home $20,000 a year, all that they can get from me is, what is that? $5,000. I can still live on $15,000 a year if I have to. Now, that doesn't sound like a lot, but a lot of people say, well, what can they do to me? Can they, in effect, put me out of my misery? And the answer is no. These exemptions are very real. O.J. Simpson is the classic example of the person who has a judgment against him who deserves it, and they've been chasing him for a long time. The power of the court is large in regard to that judgment. You see, they finally pushed him, I believe, over the edge so that he acted as he did and got caught as he did. But the quick on it is that the power of a court and a creditor is pretty dramatic. However, they can in Alabama, and I'm sure it's the same in Tennessee, is that at least your dignity is protected. Now, Becca, I've talked to them about the economic distress and the bankruptcy. Why don't you tell them a little bit about vicarious liability? I would suggest you first tell them what vicarious liability is. Yes, sir. Yes, sir. Ed?
You mentioned pension.
Yes.
What about 401k?
They're okay.
Okay.
You're protected. It's
Well,
a pension.
I'll tell you what vicarious liability is. It's when you're liable for the acts of someone else. And a lot of times you'll see this in the context of parents being liable for the actions of their children, or you'll see it in the context of a company being liable for the acts of an employee. Now, a lot of people ask, what is the liability of a parent for the destruction of property by their child? Well, an Alabama statute addresses this, and it says that a parent who has custody of a child, and if the child is living with that parent, can be liable for up to $1,000 for destruction of private property. Now, you also have to remember negligent entrustment. Have y'all ever heard of negligent entrustment? The law says if you let an underage driver drive, or really a drunk anyone drive, then you can be liable whether that person's your child or not. So while talking about vicarious liability, if you let someone borrow your car and they wreck it and injure someone else, are you liable just because you're the owner of the car? And the answer to that question is no. Another question you get will your insurance policy cover that damage, or will your friend you loan the car to will his insurance company be liable? And the answer to the question is that your insurance policy will have to cover it. The insurance policy follows the car, not the person. Your insurance will cover it first, then his second. Now, while on this subject, what about a landowner's liability if someone is hurt on his land? The landowner is not liable just because someone is hurt on his land. That person has to be negligent as to invitees onto the land, or as to trespassers, they have to knowingly leave a trap of some sort, or knowingly have some sort of danger which they didn't fix. So, now that we've talked about vicarious liability, we're going to address elder law. And Dad, since you're the oldest, I'm going to let you talk about it.
31 years? No, that's badge of courage or a badge of honor. My dear friend Connie Glass talked to you about elder law. Now, it is a very complicated thing, and I will tell you, even my old high school coach called me today and said, by the way, what's that girl's name you told me to call? And I said, Connie Glass. As my mother, her grandmother, I took her to Connie Glass and Carol Wallace years ago. But I'm going to give you their course in about 2 sentences. Ready? 5 years. If you could just last 5 years, Grandma, 5 years, and then never keep more than $2,000 in the bank. You got it? That's all you got to do. Then the state can take care of your nursing home. I was talking to a friend of mine who's out there in Summerby, the old Summerby, and it's about $3,000 to $4,000 a month is what it would cost to live there in style, and I think Summerby is as good a place as there is in Huntsville. But you can get Medicaid if you're smart enough to last 5 years and keep less than $2,000 in the bank. Now, when you transfer your property, the way you do it is like this. You deed it to your 5 children, and then you have the mother keep the life estate in the property. And Wayland Cooley, who was our old tax assessor, and the way that they're doing it even now is that you will still get the tax break of an old person. In other words, as far as the property taxes, you'll get a break for it. Because they understand what you're doing. Basically, it's in trust for the grandmother for her life. And that's the way you do it. You deed it to the children and give it back to the mother with a life estate in it. And that way, Medicaid can't touch it. Now, let me disclaim everything I just said to you, because I've read all the certifications that Connie Glass and Carol Wallace have had. However, it's worked so far for me for the last 36 years, and if it really gets more complicated, consult one of those elder law attorneys. That's elder law in a nutshell. 5 years and $2,000. Now, Becca, that's when you really, really owe. If you will tell them what happens when they really, really die, inheritance law, if you will address that subject, because this always comes up in my law practice. I can be in the most complicated trial in the world. I can be in medical malpractice cases, but everybody wants to know what happens if you die. Will the state get my property? Who gets it if you die without a will in Alabama? Becca?
Well, in Alabama, if you die without a will and there are no children, and I'm just going to assume that the husband dies just for purposes of discussion. If there are no children and if the husband has no parents, then the wife will get the entire estate. If there are no children, but the husband has one parent, then the wife will get $100,000 plus half of the estate. If there are children and all of the children are the wife's children as well, then the wife gets the first $50,000 and half of the estate. And if there are children, but at least one of the children is not the wife's child, then the wife will get the first $50,000. She doesn't get, I'm sorry, the wife will get half of the estate. She does not get the $50,000. What does everybody else get? Well, when you think this through, or when you look at the statute, it always goes down to the children first and then up to the parents. So if there are no children and there are no parents to the deceased, then the estate will go to the nieces and nephews. So you can generally follow the rule that it goes down to the children first and then up to the parents. Dad, will you please address divorce law?
Yes, and in fact, as I do, the first thing I'll mention to you is, Becca, you forgot to mention what happens when she really hates him and wants to disinherit him completely from the will. Well, she can't do it. Because, and we use the example of husband dies first and then the wife, but it would be the same, would be if the reverse were true, is regarding who dies first. But one spouse may not disinherit the other up to 1/3. If, in fact, the spouse who is being disinherited does not have any money, does not have a same or similar estate. In other words, if they both have $1 million, it really doesn't matter. But let's say he has the $1 million and the wife has nothing and he dies, she can come in and say, I disagree that his inheritance plan, I will not allow it and I object to it and I insist on 1/3 of his estate. That is by law. He has the right, she has the right to object to it, and he does too. Spouse, we used to call it courtesy and dower, and under our new statutes 20 years ago, that I'm not sure what they call it, but that's it. Now I'm leading. Yes, sir.
I have a question. Who enforces the intestate statutes?
Well, let me tell you how they are enforced. Your question is who enforces the intestate statutes. When somebody dies in Alabama, you must give notice to all of the bodily heirs of the deceased. And as Becca just said, you look down first and then you go up. If you look down and he has children, you must give all of those children notice. And then they have the right to come in and they have the right to object. And also your probate judge and your circuit judge, they're under a duty to follow the law, and they will. I've seen monies paid into court, and there they sit on estates and probate estates. Somebody inquired of a probate, say, what happens when money's paid into court? It will sit there for a long time in an interest-bearing account, usually. But who enforces it? The heirs who have the rights to it do. The judge, when he closes out the estate, the judge will take a look and say, wait a minute, this percentage goes to that heir. And that's where it goes, and they will look.
Well, most people in Alabama, most people think that when a spouse dies, the other spouse gets 100%. And as you just pointed out,
Right.
in the intestate, that's not necessarily true.
No, it isn't. But if you've got a will, let me tell you, if you've got a will, it goes according to the will. And the best reason to have a will is because you can have your son who lives in New Jersey, let him do it. He can't be the executor if he's an out-of-state resident. If I don't have a will when I die, Becca, my smart daughter here, cannot be the executor. She would be forbidden. And that's a big, also you would have to get a bond, and that costs money, hundreds of dollars for a bond. So think about this, get a will, go see one of these real live lawyers who do wills. If you've got an estate worth substantial money, go see a real lawyer. By the way, the exemption this year is $3 million, and so you don't really have tax problems. You don't necessarily need a tax lawyer, but you need one that knows what they're doing. Think about that. Yes, sir.
Probate, are you required to go through probate?
The question is, are you required to go through probate? And the answer is no. But if you're going to wait either 2 or 5 years to do anything about your property, that's the answer. So you want to wait. I have an estate right now, a house in Blossomwood just sold, but the lady who died, she was the second wife, and she wants to sell the house. Well, she can't sell that house. Her loving husband had 3 other children, and they're grown, and we got to clear that title up. and I'm advising my client. I said, look, you can't buy that house. Title is not clear until the will is probated, until we wait the appropriate length of time. Yes, sir.
How long can it stay in probate? Is there a time limit?
No, there's no limit. It can stay forever. After 20 years, it is presumed to be settled. And you need to give in your will, you need to give your executor powers so that they can act. Yes, sir. Yes, sir.
If both, all of your children are out of state, you don't have any children in the state where you are.
Yes.
We have our out-of-state daughters,
Yes.
our executor, so what happens?
That's good.
You can't
No, what I said was, the law is that if you write a will, you can say my out-of-state child can be the executor. But our court will not approve or appoint somebody if you don't write it in your will. All right, now, we're moving from topic to topic. And the reason that I'm doing this tonight is because these topics come up all the time in my practice, in everybody's practice, as you can see. You need to know these things. I don't care what kind of case you have. I've tried medical malpractice cases, maritime cases, car wreck cases, criminal cases, you name it. But these issues always come up because you're always going to have to face your maker one day and address these things. Now, if you're charged with a crime, usually the constitutional law, our next topic here is going to be constitutional law. And let me jump to a couple of quick conclusions here. Constitutional law is so confusing, and we've heard it in the debates over the last few weeks. It's not in the Constitution. Lord, nothing's in the Constitution. It's just whatever they want it to be. Now, but let me tell you how it works. When you hear these criminal lawyers, when you hear people like Mark McDaniel or Roy Miller or Barry Abston or these people, or you're going to hear at least one other criminal lawyer talk in a couple of weeks, when they talk about constitutional rights and law, here's what they're really saying. Ladies and gentlemen of the jury, there are 12 of you. I want you to be fair. I want you to do what you think is right. But I know that all 12 of you must agree. And if I can find one of you who is so hard-headed and principled that you'll hang it up, just like in that movie, the Juror, or all those, where one juror hangs it up, because you will exercise your constitutional rights. You will be strong. And you will stand by what you believe in. And exercise your constitutional rights. You will have done your duty. Like Mark McDaniel said, you haven't heard any evidence here. You haven't seen this show. You haven't seen the circus. All you've seen is the parade. I don't know where he got that. However, a dear friend of mine, well, let me say this. Becca had an observation, and
Well, you want me to cut in? Along this line, Bobby Kennedy said this in 1966 in South Africa. This is his address, and I'm going to read it. Some believe there is nothing one man or one woman can do against the enormous array of the world's ills. Yet many of the world's great moments of thought and action have flowed from the work of a single person. A young monk began the Protestant Revolution. A young general extended an empire from Macedonia to the borders of the earth, and a young woman reclaimed the territory of France. It was a young Italian explorer who discovered the New World, and the 32-year-old Thomas Jefferson who proclaimed that all men are created equal. These people move the world, and so can we all. Few will have the greatness to bend history itself, but each of us can work to change a small portion of events. And in the total of all these acts will be written the history of this generation. It is from numberless diverse acts of courage and belief that human history is shaped. Each time a person stands up for an ideal, or acts to improve the lot of others, or strikes out against injustice, he or she sends forth a tiny ripple of hope, and crossing each other from a million different centers of energy and daring those ripples, build a current that can sweep down the mightiest walls of oppression and resistance.
are you that ripple of hope? Will you tear down the walls of oppression? Well, let me tell you that that's how it comes up in the courtroom, in the real life. I want to, what we're talking about here are people that have stand up and have changed history, like George Washington, the Bear Bryant of his day. And I'm going to get to that in just a minute. Wasn't he? But let me divert just a minute. Talk about constitutional law in another aspect here. When we're talking about constitutional law, first let's ask, what is the law? What is the law? Judge Snodgrass said it best once. He said, law is simply the codification of reason. Does everybody agree? I do. But remember, you say, well, this is the law, therefore it is reasonable. But if you think about it, it took us until 1964 to actually create a vehicle, the Civil Rights Bill, to effect the rule that all men are created equal, as Thomas Jefferson said. It took us till 1964. Now, I was born in 1949. In 1942, if you ride down Whitesburg, headed south, there's a subdivision called Mayfair. And the law at that time was, according to the probate records and according to the restrictions there, were that no property shall be sold or leased or occupied by anyone other than a member of the Caucasian race except in the capacity of a servant. That's Mayfair. Thornton Avenue, Bibb Road, Surrey. Only in the capacity of a servant shall anyone other than a Caucasian live there. Now, I don't want you to think that neighborhood is special. Let's go to the deed at Goldsmith Schiffman Phil. Said property shall be used only for the enjoyment of the white students for recreational purposes. Now, was that fair? Who said life was fair? I don't know. But when you talk about constitutional law and what we as lawyers do in trying to interpret these, do y'all remember a few years ago we had Fred Gray? Fred Gray, who was Martin Luther King's lawyer, come here and speak right here a few years ago. Every now and then we try to play his tape every Martin Luther King Day. Guy's about this tall. It's the meanest little son of a gun I've ever seen in my life. Martin Luther King was like 2 years older than him. He was 24 when he got out of law school, but they enforced those laws. And what I always thought was so interesting about Fred Gray, he and Rosa Parks, they'd eat a sandwich there every day for lunch together at their little office. They shared an office space. I don't know what they did, but they're sitting there eating bologna sandwiches. The only way I can figure it, I asked him, I said, y'all were sitting there scheming about how to bring down the bus line, weren't you? And he never will say that. But I want to tell you a little bit about, before I get to George Washington, I want you to tell us, how can you, in the constitutional law aspect, how can you defend a guilty man, Becca?
Well, often when you hear this question, you might think of John Adams, who some of you may or may not know. He defended the British soldiers who were charged with murder in the Boston Massacre. Who said these guys are guilty? You? Are you the king? It used to be that way, but that's not our system anymore. The way we do it is to charge a person and then advocate for that person. An advocate for that person would be appointed to make sure that the rights of all of us under our Constitution are protected. Someone said when they wrote the Constitution 200 years ago, Thomas Jefferson didn't know Richard Nixon, but he saw him coming. Bobby Lee Cook of Summerville, Georgia, upon whom Matlock was patterned, once said he once got frustrated trying to explain why he was defending a man charged with murder. And he said he got tired of explaining to everyone why he did this under the Constitution and the Bill of Rights. So when asked by someone, he finally said, the man just paid me $250,000. And suddenly everyone just understood. He said, go get him. That's great. So that's con law at its most primitive. Senator Sam Ervin said, if you locked everyone up you think might commit a crime, then you'll be pretty safe, but you won't be free. And Mark Twain said, the more you explain it, the less I understand it. So what happened with John Adams? The British soldiers were found not guilty, and he later said that it was the finest piece of legal work he ever did.
Now I want to go to George Washington. You know, history, I see a lot of political science and history students in law school, and they are so connected, I can't help it. It's so hard for me to separate it, and I find it so interesting about him. I didn't know much about George Washington. I always, being from the South, I always read about Robert E. Lee. But I will tell you that George Washington, the influence that one man had, was a great ripple of hope to this entire nation and to this world. King George III of England said, upon learning that George Washington intended to reject the mantle of emperor, King George III said, if he does that, he will be the greatest man in the world. A lot of you don't know this, that when George Washington was in the General Braddock's campaign at Fort Duquesne, near what is now Pittsburgh, and they were defeated by the French, that he and Daniel Boone fought to rally the survivors, and that George Washington was shot at and had multiple bullet holes through his coat and pants while being so brave to rescue those. He and Daniel Boone did. I had never made the connection that George Washington and Daniel Boone were together, but apparently they were. Also, they say that at Yorktown, at the very end of the war, that he stood on the parapet for 15 full minutes just staring at the British cannon, and they were still shooting at him, and he wouldn't come down. And that one act of bravery alone earned him the respect, so that a few years later, when they said who would lead, he was the father of our country wasn't even formed, and they said that George Washington was the father of our country. Now, I allude to this to say, and I'm being rather summary about it, but in a criminal jury trial, these kinds of things are brought up because, again, the question is who's going to be the George Washington today? Yes, sir.
Isn't the law who's in charge? And since the laws constantly change, isn't it possible anyone could become a criminal?
Oh, yes. Our next speaker is the former district attorney, Fred Simpson, and he and his son have tried many, many criminal cases. And in talking to him, and also to my friend Mark McDaniel and the late David Cromwell Johnson, they all say it is just fascinating how many crimes they're constantly making up and inventing now for you to break. It's just unbelievable. Attorney Bud Watson said that he had a friend named Ed Green that said he was such a hardliner that he said we need to put everybody in jail and only let them out when they're good. Ed Green, I worked with Ed Green. He's a great man. Back to George Washington. George Washington's family, where did he come from? I looked it up. Genealogically speaking, for 6 generations back to the Magna Carta, his people, one of the 25 that signed the Magna Carta, and then George Washington himself and his family, they go back to and through English history as being very brave people. Also, let me mention Robert E. Lee. He was a descendant of a man named Lancelot Lee. Isn't that interesting? And now we shall touch on the ultimate subject, and that is law and religion. You gonna do it, or you gonna let me?
I'll let you.
Thank you.
This is your expertise. It's all you.
Well, let me tell you why it's so important. Is it wrong to sue? Every time I strike a jury, I'll ask, does anybody here think it's wrong to sue? And somebody's going to raise their hand because he or she goes to the you-know-what, something or other fundamentalist church, and they have read that it's wrong to sue. And I tell them, and I really believe it, let me tell you something. The Bible talked all about lawsuits all the way through it. It talked about widows and orphans and protecting them. This is Caesar's court. You are in Caesar's court. And Jesus said, give unto Caesar what is Caesar's. This is Caesar's court. I will also tell you that the trial lawyers stand up for those who cannot protect themselves. The defense lawyers, this is our slang and talking to them, we say their philosophy is let the big dog eat. You don't need to come to court if you own everything, you are rich, you have written the laws to favor yourself and out. You don't need umpires, and you don't need to be called to a system of justice. You don't need to go to Caesar's court if you've already bought the whole city and you own it anyway. Caesar's court is for those who need protection. We represent the poor, the downtrodden, the oppressed, those who are on the side of the angels. Now that's the sermon. I say sort of, but the book of Isaiah says, woe be unto those that decree unrighteous decrees, that turn away the needy from judgment, so that widows and orphans may be their prey. That's what the book of Isaiah says. Yes, the courts have been here for a long, long time, and I don't know who told you you couldn't sue, but yes, sir, we're here to correct a difficult situation. Mark Twain in Patriotism said that patriotism is the bastion of a scoundrel, and that the same is true of a lawyer quoting the Bible. But for those who reject religion in the afterlife, Dr. Von Braun said this: science has a real surprise for the skeptics. Science, for instance, said Dr. Von Braun, tells us that nothing in nature, not even the tiniest particle, can disappear without a trace. Think about that for a minute. Once you do, your thoughts will never be the same. Science has found that nothing can disappear without a trace. Nature does not know extinction. All it knows is transformation. That's according to Dr. Von Braun. We talk about trials. The greatest trial there ever was. It's been studied for 20 centuries. The trial of Jesus. Court systems existed back during that period of time. The Sanhedrin court was where he was tried. Do you remember? Remember, he was tried before the court of Sanhedrin. There were 71 elders. He was tried and charged with blasphemy. Remember, regarding the 71, that the Lord told Moses as he was entering the promised land, he said, gather unto you 70 of the elders, and you may govern the nation. They will help you govern the nation. Those 71 were the ones who tried Jesus. They were divided into 3 sections. There were the priests, who were the religious. There were the scribes, the Sadducees and Pharisees, who were the lawyers. And then there were the elders, who were the popularly elected and selected people. All of these people had the equivalent of PhDs and could speak more than one language and had children. The writings note that the scribes frequently encroached on the rights of the other 2 sections, the lawyers, obviously. But during the trial of Jesus, there were 3 gross errors committed. First, he was tried at night. To this day, our Alabama Code has special rules regarding doing anything at night. We always had the legal hours, remember? There's a reason people act crazy at night, don't they? Human nature, the codification of reason. He was tried at night. Number 2, during the trial, Caiaphas, remember, the high priest, rent his clothes. Under the rules of procedure of the Sanhedrin, the way that you voted for guilt or innocence, or whether to pass, was that the youngest voted first. That way the youngest would not be affected by the eldest and wisest and richest and most influential. Therefore the youngest voted first, then the next and the next. Reverse order of seniority is the way you voted. So that when Caiaphas the high priest rent his clothes, when he heard Jesus say what he said, he disclosed his vote. And that was reversible error, or should have been. Last, he was convicted in one day, before a holiday. If you remember, this was the Passover. And he was convicted before the holiday. Now, I remember no one should ever be tried and prosecuted before a holiday. I'm going to tell you a quick story. Years ago, there was a district attorney named Well, Fred Simpson, who had a young assistant attorney named Roy Miller, who was prosecuting a woman who had killed her husband because he brought his girlfriend home to meet her. The trial, Roy Miller was the assistant district attorney. We all know who Roy Miller is. He represents the professor at UAH. But the jury went out on 5 o'clock Friday afternoon, and they came back on Good Friday. It was Easter weekend. And they found her not guilty in about an hour. Later at a press conference, Fred Simpson, they said, well, Fred, how do you feel that a woman who shot her husband in cold blood, how do you feel that she committed murder and got off with it? And Fred Simpson, who you're about to hear from, he said, you know what, the way I figure it, that lady, she didn't commit murder, that man committed suicide. But the problem is that they found they made a decision in one day and before holiday, and that was forbidden. And those three eras have been talked about by trial lawyers for 20 centuries in that court of law in regard to that particular decision. And I say that that's all that I will say in regard to this, except that I heard Johnny Cochran speak one time. Johnny Cochran was sensational. I will tell you just a couple of things. We're just about out of time, but I will tell you. Johnny Cochran, he was Judge Ito's boss for 10 years in the district attorney's office. Did you know that? Number two, he tried 2 cases in 1 week. Out there in L.A., they were going 3 shifts a day using their court system. So he tried a $1 million car wreck case during first shift, and in the second shift, he tried a murder case in 1 week, Monday through Friday. And he got a $1 million verdict in the car wreck case, and he got a not guilty conviction in the murder case. Excuse me, in the car wreck, he won both cases. He is a hard-working man, but he says you must always have a theme. Always have a theme in your case, and always have a plan, and always conclude with your theme. Now, having said that, I will tell you that the defendants always try to make light of your jury's decisions and try to show that it really doesn't matter. We always run red lights. It's okay to run red lights. We always run red lights. It really doesn't matter. It doesn't matter what your decision will be. It just really doesn't matter. What you're about to hear is maybe how we think that you should approach it in regard to the theme of your particular case and what you should do in that particular instance.
One day an old man was walking on the beach. It was low tide. The sand was littered with thousands of stranded starfish that the water had carried in and left behind. The man found himself carefully trying not to step on the beautiful creatures, since the animals, the little starfish, were still alive. He considered picking some of them up and throwing them back in the water so that they could live, so that they could resume their lives. The man knew that the starfish would die if they were left on the sand, and he reasoned that he could not possibly pick up all of the starfish. So he chose just to not help anybody. That's just nature's way, he thought to himself as he walked sadly along the beach. Soon he came across a little boy who was frantically throwing one starfish after another back into the sea. The old man stopped. "Young man, what are you doing?" The little boy said, "I'm saving the starfish," he answered breathlessly. "Why waste your time?" the old man argued. "There are so many of these starfish you can't possibly save them all. So what difference does it make?" And the little boy stopped for a few seconds to look up at the old man, and he bent down and picked up another starfish and said, "It matters to this one, and it matters to this one."
Thank you. Thank you so much.